someone who one would say needs no introduction. And then, of course, I go on to the introduction, because it is important that you know these things, because if we are to respect this organization, we have to respect the people who have helped find it. Howard Nations is a past president of the Bell Eye Society, a past president of the Texas Trial Lawyers Association, a past president of the Southern Trial Lawyers Association, and a trustee of the American Jury Foundation. After 40 years of legal lecturing, and as a founder and former chair of the American Association for Justice National College of Advocacy, formerly known as Atlas National College of Advocacy, what we're doing here today, Mr. Nations is responsible for the vision of lecturing 40 years later to a room full of attorneys. We're probably about 160, 170, maybe even more, 200 in number. And each of us being rejuvenated by the experience of sharing our experiences with each other. And for that, we have Mr. Nations and so many others to thank. So without further ado, Mr. Howard Nations.
Summation. First of all, there has to be a symbiotic relationship between what I call the trilogy of persuasion, the 3 times that we get to address a jury directly. Summation begins with voir dire examination. You set it up on voir dire examination. Then you certainly set it up, absolutely set it up in the opening statement. And then you bring it home in summation, in the closing argument. And you carefully divide your time and how you use your closing argument between the first part of it and the last part of it. And we were talking about just about the issues about talking about money in those times, talking about money. When do you begin talking about money? What we're told today by the forensic psychologist is that now, before we start talking about specific large sums of money, we really need permission to do so, because there's skepticism on the part of the jurors against us and against our clients going in. And if we stand up and start trying to argue damages in voir dire or opening as we used to, it'll be seen as manipulation. So they have to understand, before we get to the issue of damages, they have to understand why damages are involved in this case at all. Why do they care how much damages there are? So you have to establish very clearly and unequivocally your liability before you start talking seriously about what your serious damages numbers are. We communicate with jurors in 3 ways: verbally, vocally, and non-verbally. And in our non-verbal communication, so much of that in summation is like this. I can't do it from here because I shouldn't be, if I'm going to be communicating with you, you shouldn't be having to look up at me. Communication is this. It's eyeball to eyeball. The approach to the jury is this. It's the open-handed approach. Look like anybody you know? This was the characterization as the theater teaches you. This is the Jesus approach. That's what they call it in the theater. You've opened yourself up. You have nothing to hide. And you're asking them to listen to what you have to say and become a part of it. So think about your nonverbal communication. Also, our friends from the theater teach us that this is not how you do a summation. You don't walk back and forth in front of a jury box looking at the floor. You also don't walk back and forth in front of a jury box looking at jurors. You make a contact. You finish a thought with that person, and then you can very subtly move on to the next person with your next thought, with your next point. And then you move, and you make absolutely sure that you're involving everyone in eye contact. But you don't do it like this. It's not, Hi, I'm going to say a few words to you. Now it's your turn. Oh, hey, it's your turn. Let's talk for a while. It's moved. It's much more subtle, but you have to be you're not communicating with one person. You're communicating with all 12 all the time, but you're making eye contact with each person individually so that you get that communication working. I want to talk about defense themes and, and how we approach them. I began my career as a defense lawyer for 5 years. I worked with, I represented insurance companies and corporations, hospitals in medical negligence cases. And it was a wonderful education. That's in Houston, that's basically what we do. Most of the big-time plaintiffs' lawyers in Houston started out with the big law firms in Houston. We go over, train for 3 or 4 years there, and then move on, and then ask forgiveness for the rest of our lives. But what I learned there has been so incredibly valuable. I like to do a thing called thematic reversal. I like to determine what is the defendant's theme in this case, and then reverse it. Take it away from them on voir dire so they never get a chance to actually use it effectively. You can actually anchor your response to their theme. For example, if you've tried a traumatic brain injury case, what's called the mild brain injury, I've always thought a mild brain injury is one that happens to somebody else. But the mild brain injury case is the one that doesn't show up on any type of imaging. No x-ray, no MRI, no CAT scan. It just doesn't show up anywhere. It shows up in neuropsychological testing, and then eventually we know they exist because it shows up on autopsy. But so it's a neuropsychological workup. The defense theme is always, if you can't see it, it's not there. Can't see it on MRI, can't see it on CAT scan, can't see it on anything. If you can't see it, it's not there. So I like to reverse that theme on them and start in voir dire examination by talking to people on the jury about, I tell them, the defense theme in this case is, if you can't see it, it's not there. Now let's talk about some of the things that we can't see, but we know are there, that are pretty important to us. And people come up with things like oxygen. And then they get into things like faith and God and that. I don't get into that discussion. I just let them say it and move on. But the whole idea is you start them to thinking that there are other ways of doing things. And then you explain that the way this is handled medically is that right now technology is still lagging behind injury. The reason we can't see it is not because it's not there, it's because technology has not come to that point yet. 30 years ago, we couldn't see a lot of things that we can see on MRIs today. They were there, we just couldn't see them. So you go with that. But then you have to determine, how do you see it? Well, you see it, you determine it through circumstantial evidence. So you talk to them about circumstantial evidence, and you're setting all this up for you're setting up several things here. You're setting up this testimony of your neuropsychologist. So when he comes in and starts explaining the test that he's done and the results he got, they understand what that's all about. They understand that this is circumstantial evidence of a brain injury. So then you have to explain circumstantial evidence. What is circumstantial evidence? We usually ask on voir dire, again, you start it there. Remember Robinson Crusoe. He thinks he's alone on an island. What did he see that let him know he wasn't alone? He saw a footprint in the sand, a human footprint. He did not see the man. He did not see Friday for some time thereafter. But he saw a human footprint in the sand that was not his. That was circumstantial evidence of the presence of another human on the island. That's classic circumstantial evidence. Circumstantial evidence, when you're locked in that jury room, there are no windows, but if you leave at the end of the day and you see the streets are wet and there are drops of water on your windshield when you get in your car, you can reasonably assume from circumstantial evidence that it rained while you were in the jury room. That's circumstantial. That's the type of evidence that the court will tell you you may consider in arriving at the decision on a brain injury. And then you set that up. That sets up your closing argument for that. One of the defense tactics that we always like to use was who's being honest with you in this case? I remember when I tried my very first, and I tell you this by way of caution, that we have to be careful. This is one of those reasons we don't put a lot of money up there on the board in the beginning or make outrageous claims. I tried my very first case from the defense, and the defense lawyer came in just routinely said, I mean, this was back when the earth was first cooling, and it was $250,000 was a huge amount of money. And the plaintiff's lawyer, simple little auto accident case, and it was worth about $25,000. But he had pled for $250,000. So I told the jury, on my opening statement as defense lawyer, I said, let me tell you what this case is truly about. The plaintiff has said it's a $250,000 case. So let me tell you what it's really about. And I went to the board and I put up the special damages, just like you saw here. I put up special damages. There's this much in medical, there's 2 weeks lost time from work, there's this much property damage, there's this much, this totals. And then if you're feeling very generous at the end of the day, let's say you're feeling extremely generous and you put $5,000 for general damages. The total, what this case is really about is $18,742.18. Now, I'm going to listen. Plaintiff's lawyer has told us, we heard him, it's a $250,000 case. So I'm going to listen along with all of you. And I'm going to listen for that other $232,000, the evidence of that other $232,000. And at the end, when I stand up to address you at the end of this case, the first question I'm going to ask you is this: who has been honest with you in this case? And of course, he doesn't have evidence of the other $232,000. I know it, he knows it. So at the end of the day, I stand up and ask that question, and who's being honest? And the numbers they're seeing on the board now are the same numbers they saw in the beginning. That's a tricky thing. So that's what can happen to you if you overstate your case. So when I went over to the defense side, I went to the side of truth and justice, I started thinking, okay, how can I reverse that? So you'd have to be sure you could do this in your state, but I took the pleading. You know, the insecure lawyers follow a form and they plead absolutely everything they can think of because they're afraid they'll miss something.